At least I thought. Where are you, Mr. Reagan? I thought he's not in the. I clicked him in to join. Okay. All right. As I indicated, he pump faked me. Okay. Oh, it's Mr. Bird. No wonder. I should have figured. All right, Mr. Bird. Okay, accept the invitation. All right, Mr. Higginbotham, as it indicated, you have some traffic matters which you failed to appear in court for. As a result of failure to appear, a warrant for arrest were issued. The court's going to set aside these arrest warrants, give you a personal bond in each of these misdemeanor matters that carries a maximum penalty of up to 90 days in jail and or a $500 fine. You have the right to remain silent. Anything you say can or will be against you. You have the right to an attorney. You can't afford an attorney. One will be appointed on your behalf. The tickets are P1310608, no insurance misdemeanor. Ticket P1485470, no insurance misdemeanor. Driver license not valid. Ticket P1486542, no insurance misdemeanor. Driver license expired. Ticket P1523347, no insurance misdemeanor. Driver license not valid. Ticket P1585473, smoking marijuana within the passenger area of a vehicle. Ticket U63490122, narcotic and drug-related paraphernalia violations. And ticket P1539657, driving the rest of motor vehicle, no insurance misdemeanor, driver license not valid. And all of these misdemeanor matters, sir, you're given a personal bond, no dollar amount. Pre-trial will be February 28th in front of Judge Millhouse. Now to your main matter. This is case number 240-610-2701. Houston, Michigan versus Darren Higginbotham. Appearances, please.
Thank you, Magistrate. Steve Benson for the people.
And good morning, Your Honor. Sydney Rushing, P78830, appearing on behalf of Mr. Higginbotham. Mr. Higginbotham has been advised of his constitutional rights, waives formal reading, stands mute, and asks that a not guilty plea be entered on his behalf.
Court read a not guilty plea on his behalf. Mr. Vincent, you say you had no objection to a personal bond in this matter?
Yeah, serious but non-assaultive incident took place about 7 months ago, no priors.
No objection to personal bond, Judge.
$5,000 personal bond, Mr. Higginbotham, while his case is pending. You not to possess any handguns, firearms, or other dangerous weapons. Probable cause, January 31st, in front of Judge Kevin Robbins. Preliminary examination, February 7th, in front of Judge Giles. Step aside, please. All right, Ms. Rushing, are you ready on Burrell? She didn't hear me.
Oh, I'm sorry. No, I was muted. That was my fault. Yes, Judge, I'm ready.
Okay, we're going to do this gentleman first. Sir, what's your name?
Dustin Miller.
Dustin Miller?
Yes, sir.
All right. This is case number 240-575-9901. Houston, Michigan versus Dustin Miller. Appearances, please.
Lisa Coyle appearing on behalf of the people.
And good morning, Your Honor. Sydney Rushing, P78830, appearing on behalf of Mr. Miller. Mr. Miller has been advised of his constitutional rights, waives formal reading, stands mute, and asks that a not guilty plea be entered on his behalf.
All right, the court read a not guilty plea on behalf of Mr. Miller. Bond recommendation from the people.
Your Honor, there is no capious history on this case, although it occurred back in November of 23. But I do see a serious issue here. This was a rollover crash. His blood alcohol level was a 0.33. Very dangerous to the community because his OWIs, his priors, are from a 2016 and a 2015. They're somewhat recent, and based on the blood alcohol level, it tells me that he has a continuing issue with substance abuse. So for those reasons, Your Honor, based on the danger to the community standard, I'm asking for a $10,000 cash surety or a 10% bond, and I'm also asking for an alcohol tether as well. No driving.
God, I'm
Hold on, Mr. Miller. Mr. Miller, hold on. Your Honor, if I may.
Sure.
Your Honor, we're asking for a personal bond in this matter as well as no alcohol tether. This incident date is from November 19 of 2023. The warrant was not signed until June 6th of 2024. And Mr. Miller came into custody after a traffic stop on the 23rd of this year. He wasn't aware of this warrant. He would have turned himself in if he was aware of it. Again, there was over 7 months between the incident date and the warrant being signed, and he had no idea of it. Otherwise, again, he would have turned himself in. So, Your Honor, I don't believe that there needs to be a cash bond in this. As the people stated, they have no indication of prior KPS history. So there's nothing to suggest that Mr. Miller will not show up to court. Further, Your Honor, with after talking with our clients, he understands that he is not going to be able to drive during this time. So again, with the delay,
well, no, hold on, Mr. Rusty. He's not to drive unless he does not have a valid license.
Okay, well, I'm just saying, Judge, we did talk with him, and he understands that he could have been ordered to not drive at all, and he understands that.
Right. Okay.
So we're asking for a personal bond, no alcohol tether. Obviously, with this warrant getting issued in June, again 7 months after the incident date, he hasn't had any contacts with police since then. So we're asking for, again, personal bond, no tether.
Okay, the court having heard argument as to bond. This is a alleged repeated pattern of behavior, and notwithstanding the fact that this incident occurred in 2023, that is a large amount of alcohol in one system from the blood draw here, which suggests that Mr. Miller allegedly has a high tolerance for alcohol and more importantly, has a problem consuming alcohol, a repeated problem with consuming alcohol. So I do find him a danger, potentially danger, particularly if he continues to drive while intoxicated. Now, to your point, Ms. Rushing, this is a slightly older offense, and the court's factoring that into its bond decision as well. But in the interest of protecting the community and the least restrictive means, I am going to give Mr. Miller a $20,000 personal bond, but he will have an alcohol tether.
Mr. Miller.
And so if he does drive, I'm going to make sure he doesn't have anything in the system that he shouldn't have to protect the community. So no alcohol. You'll be fitted with an alcohol tether. No driving unless you have a valid driver's license. Probable cause February 4th. Preliminary examination February 11th. Both in front of Judge Taylor. Is there anything else either counsel wants to put on the record?
Nothing further, thank you.
Nothing further, Your Honor. Thank you so much.
Antonio Marcellus Sanders.
What's your name?
Antonio Marcellus Sanders.
Mr. Sanders, you have some traffic matters which you failed to appear in court for. As a result of your failure to appear, warrants for your arrest were issued. The court's going to set aside these arrest warrants, give you a personal bond in each of these misdemeanor matters that carries a maximum penalty of up to 93 days in jail and/or a $500 fine. You have the right to remain silent. Anything you say can and will be against you. You have a right to an attorney. You can afford an attorney. One will be appointed on your behalf. Mr. Sanders, the ticket is P1553193. Failed display of valid operator's license. Pre-trial for this ticket will be February 28th in front of Judge Roberta Archer. Now to your main matter. This is case number 250-553-8701. Pearson Michigan versus Antonio Sanders. Appearances, please.
Thank you, Magistrate. Steve Benson for the people.
And good morning, Your Honor. Sydney Rushing, P78830, appearing on behalf of Mr. Sanders. Mr. Sanders has been advised of his constitutional rights, waives formal reading, stands mute, and asks that a not guilty plea be entered on his behalf.
Okay, the court will not guilty plea on behalf of your client. Bond recommendation from the people.
Magistrate, we're going to be asking for a $10,000 cash surety. We're going to be asking for an alcohol tether unlike the previous OWI case that was just heard before this court, this just occurred allegedly January 19th, which was just 2 or 3 days ago. This defendant has a substantial prior history for substance abuse. It is an OWI third. His previous 2 convictions have all occurred within the last 3 to 4 years. He recently just got off of probation late October of 24 for his most recent OWI conviction. And then we have this defendant before us today, 3 months later, allegedly going 80 plus miles an hour on Jefferson in a 35-mile-an-hour zone, where he subsequently ended up blowing a 1-8. So respectfully, and he has a revoked license. So he was unlawfully on the roadway at the time of this. He continuously poses a danger to the community. Fortunately, nobody was hurt in this incident. However, I don't know if that takes away from the dangerousness that the defendant posed. So respectfully, we're asking for that cash with alcohol monitorization.
Thank you. Ms. Rushing?
Your Honor, we're going to be asking for a personal bond in this matter. The people did bring up that my client does have priors. However, they did not bring up any capious history. So anything to suggest that he won't come to court as he's told to. Your Honor, in relation to the alcohol tether, I definitely see the arguments for that. However, I just want Your Honor to be aware that his breath test, there was a 0.18, but there was also a 0.16. So a 0.02 difference within very close time to each other. That's a little bit of an eye raiser, but either way, that's obviously above the 0.08 limit. So Your Honor, we're asking for a personal bond in this matter. Our client will show up to court. Your Honor, I understand the request for the alcohol tether. So that is, we'd ask that you don't do it because he's going to spend some time in jail. But
Employed?
He is, Your Honor. He works construction. He works 7 a.m. to 4:30 p.m. Monday through Saturday. He's been there 6 years.
Methinks I have a suspicion he's been driving to work too.
Judge, I don't know that. You don't know that.
That's it. Methinks. I have a suspicion. I'm not accusing anything. I'm just, my spidey senses are tingling.
And Your Honor, if that is obviously a concern, I think a condition of part of bond being no driving without a valid license, I think that would,
Oh, I think he'll disregard that because he doesn't have a valid license now.
I have, in addition to what I previously said, convictions for driving with a no license at least 3 different times. Yeah.
Right. Okay. Drunk driving, if one continues to drive drunk, intoxicated behind the wheel of a vehicle, it does pose a danger to the community. Clearly, and we've all been aware of folks, as friends and family, that have been victims to drunk driving car accidents, and unfortunately, many times they've been fatal. It's kind of troublesome, particularly when someone doesn't even have a valid driver's license. However, he is employed, and in order to assure the safety of the community, I'm going to have him fitted with an alcohol tether. I am going to give him a personal bond of $50,000. No driving, sir, and no alcohol. I know I'm not so much concerned about you driving. I'm concerned about you driving with anything intoxicating in your system. That's my greater concern for the protection of the community. So if by chance you choose to drive while having a license revoked, at least alcohol won't be in your system, and so I can assure the safety of the community. and that you can maintain your job. I will say this though, Mr. Vincent's argument was very persuasive, and I was torn between whether locking you up and that'll assure you won't drive and assure you won't drink. But I do want you to continue to be employed, and I think this is the least restrictive means to not only is you can stay employed and to protect the community. But I was this close to locking you up and giving you a cash bond because, like I said, you're not even supposed to be driving to begin with.
Sir.
So with that said, probable cause February 4th, preliminary examination, February 11th, both in front of Judge Taylor. Step aside, sir.
Oh, thank you.
Okay, I have Mr. Burrell. Step up, please. No, I mean Miss Burrell. I'm sorry. It's been a weird day for me. All right. In the Wayne County Jail, are you Jimmy Jennings?
Yes.
Okay, Mr. Jennings. Before I call your case, Judge Marlena Taylor is going to log in. Can you have the deputy bring in Dowdell, please?
This is Dowdell right here.
I thought he said his name was Jennings.
We have two cameras. He's on a different camera.
Okay, all right. I'll be with you momentarily. All right, Ms. Burrell, state your name for the record.
Marita Burrell.
All right, this is case number 250-554-0501. Houston, Michigan versus Aretha Burrell. Appearances, please.
Thank you, Magistrate. And again, good morning, Steve Vincent for the people.
And good morning, Your Honor. Sydney Rushing, P 78830, appearing on behalf of Ms. Burrell. Ms. Burrell has been advised of her constitutional rights, waives formal reading, stands mute, and has a not guilty plea be entered on her behalf.
Okay, the court read on not guilty plea on behalf of Ms. Burrell. Final recommendation from the people.
Magistrate, the people aren't going to have an issue with you issuing a personal bond. I have a warrant that was actually just entered yesterday. So it seems pretty obvious that Ms. Burrell ended up figuring that out and walked herself in. People appreciate that, so no objection to a person.
Objection, person, Judge.
$2,000 personal bond, Ms. Burrell. Probable cause January 31st, preliminary examination, February 6th. No more brass knuckles, no weapons. Have a seat in the courtroom, wait for your paperwork.
Thank you so much, Judge.
Okay.
Judge, what was that PCC date? Report?
The 31st of January and February 6th for preliminary examination.
Thank you, Judge.
Okay. Mr. Rod.
Good morning, Your Honor. Good morning, everyone. Happy Friday.
Wow, nice tie.
Thanks, Judge. It's actually my favorite one.
I'm used to your weekend muscles.
Man.
All right.
I'll stand mute
All right,
for that now.
All right, DDC, what's your name, sir?
Darren Connerly.
All right, this is case number 210-443-4901. People say Michigan versus Darren Connerly. Appearances, please.
Good morning, Your Honor. Mr. Murad, good morning. Samuel A. Ragan, P23-157.
And good morning, everyone. Rad Murad, P83665 on behalf of Mr. Connerly. Waive the reading, stand mute. He's been advised of his rights.
All right, court order not guilty plea on behalf of Mr. Connerly. This is almost a 5-year-old case, Mr. Ragnar. What's your bond recommendation?
People are asking for a $10,000 personal bond.
No objection.
$10,000 personal bond, Mr. Connerly. Pretrial, February 5th in front of Judge Bryant. No contact with Michael Anaker. Step aside, please.
Thank you, Your Honor.
Thank you, Your Honor.
James Franklin Williams.
James Franklin Williams.
Yes, sir.
Good morning, Mr. Williams. How are you?
All right, myself, Judge.
Okay, this is case number 240-611-5401. People said Michigan versus James Franklin Williams, appearances, please.
Samuel A. Ragland for the people, Your Honor.
And Rad Marad, P83665, on behalf of Mr. Williams, we waive the reading. Mr. Williams stands mute. He's been advised of his rights.
Court will continue not guilty plea on behalf of Mr. Williams. Mr. Williams has a capious bond set by is it Judge Jacquet?
That's what I
1
have.
second here. Yeah. We contacted Judge Jacquet. He wants to continue the capious bond set. And so that'll be $25,000 cash surety. No contact with Michelle Huggins Wade. You cannot go back to the Tennessee address. Bond redetermination will be January 27th, 9 a.m. from the Chief Judge Mechanical. Probable cause January 31st in front of Judge Jacquet. Preliminary examination February 6th in front of Judge Jacquet. Is there anything else either counsel wants to put on the record?
No, Your Honor.
Just briefly, Your Honor, I know the court's inclined to do what it does, but it's my understanding that my client indicates there was an issue where he was never released from jail upon he was on tether, and I think it took a wait. He was taken to another
Mr.
jurisdiction.
Murad, I get that. That can be addressed on bond redetermination.
Yes. Oh, yes, Your Honor. No, I understand. I just thought we were making.
I have no authority. Judge Jacquet doesn't want to continue the bond, so I have no authority to change it. Okay, you get the court dates?
Can I have them one more time?
Bond redetermination, Monday, January 27th, 9 a.m. from Chief Judge Mechanical. Probable cause, January 31st. Preliminary examination, February 6th, both in front of Judge Jacquet.
Thank you, Your Honor.
Okay. All right, Mr. Dowdell.
Oh, can you hear me out there?
All right, this is case number 19045795501. Houston, Michigan versus Terry-Ann Dowdell. Appearances, please.
Lisa Coyle appearing on behalf of the people.
And Rad Marad, P83665, on behalf of Mr. Dowdell, we waive the reading. Mr. Dowdell stands mute. He's been advised of his rights.
Okay, the court, this has been an adjudicated case. Mr. Dowdell failed to appear for review January 21st of this year. Judge Bryant set a $100 10% capious bond. Mr. Rod, why should I not continue that bond?
Judge, he does indicate that he called in that day, was not seen. Our office has a note that we were looking for him. Just based on the fact that it's our position that he did put an effort into making it to that court date on this old non-assaultive case. I know that it's been a capious, but I'd ask for a final opportunity to be released on personal bond. He has stable residence, Judge.
This is multiple capiouses. I see
It
one
is.
in October of last year for
It
review.
is, for sure.
I mean, how many
This time we had
chances? How many chances should I give him?
We were just so close this time.
From
Judge.
March of 2023, same thing. Failed to review, given a personal bond again. I mean,
Your Honor?
Yes, Mrs. Coyle.
I
Save
see
me.
seven failures to appear.
Okay.
On January 7th, he was given a personal bond with a tether, and he's still not showing up. So I don't know if they never put the tether on him or what, but he was on, because I had this case and I recall, and so he was given a tether, and so he still failed to show up on January 21st. So at this point, Your Honor, not only is it, I mean, her bond is $100, 10%, and he still didn't show up, because every time he gets a cash bond, comes back, gets another personal bond on arraignment on a bench warrant, the bond should be 510% with the tether, as opposed to 100, because he obviously has no intention of showing up.
Yeah. Mr. Coyle, I'm going to continue the bond set by Judge Bryant for the very reasons you articulated. It serves no purpose. And, he just doesn't want to show up. It's clear. So I'm going to continue the bond set by Judge Bryant, $100, 10%.
And I'm also asking for a tether, Your Honor.
Well, I'm not going to set a tether because Judge Bryant didn't set a tether. So you're either going to continue the bond as is or give a personal bond. So $100, 10%. Bond redetermination will be Monday, January 27th, 9 a.m. in front of Chief Judge McConaughey. Review date will be February 5th in front of Judge Bryant. Sir, you had your hand up. Do you have any questions regarding your bond conditions and or court dates?
Me? Talking to me, right? Yeah, I did call the courts Monday.
Okay, sir. Mr. Rod represented all that. I get all that. Okay, that's going to be addressed on Monday at your bond redetermination hearing. Okay?
So how,
All right.
so I don't get out?
You got $10?
$10? Yeah.
Yeah, you got $10?
Yeah, I got $10.
Okay, well, yeah, you can get out of jail.
Your bond is $10, Mr. Dowda. Judge, at this point, the court's made its ruling. We have nothing further.
Okay, yeah, that's $10 US. Have a good day.
Thank you, Your Honor.
Okay. All right. Let's see here. Who do we have here? Mr. Jennings?
Yes, Your Honor.
Jennings, Judge Taylor is going to log into for your cases. I'm going to call the courtroom right now to let her know that you're available. So bear with me, okay? Oh, he looks confused. Oh, that's all right. Ms. Bailey,
Yes.
can you call Judge Taylor's courtroom so that she can log in? Okay.
Attorney Ford should be in the waiting room.
Attorney Ford?
Deborah Ford should be in the waiting room for people. She said, I'm gonna look forward.
I know.
Happy birthday.
Good morning.
Good morning. How are you?
Hi.
Hi.
Well, I just got retained on Patricia Pigler by her husband.
Okay. We're going to get to the female side momentarily. DDC, are we ready to go to the female side?
I think we have a few more minutes.
Not yet, Your Honor. Yeah, keep going.
Okay.
Judge, we ready for the females. We go to the female side now.
Thank
Okay.
you.
Your Honor.
All right.
Consent today.
He is still in the breakout room being interviewed with his attorney. He needed an interpreter.
Thank you.
Okay. And Counsel Ford, there was Mr. Jaffe, and I'm going to have him call right now. That was ahead of you. He had a client, female client as well.
Okay.
Okay. Give me one moment, please.
Okay, thank you.
Okay.
Yeah.
He's in. Disregard. He's in. Yeah. All right. Good morning, Judge Taylor.
Hey, Judge.
His office on for this matter or no?
Yeah, we have, let me rename him, Mr. Jimmy Jennings.
Okay.
And Your Honor, he has two cases that you set a cash bond for. And let me call the cases. Mr. Jennings, state your name for the record.
Jennings.
Right, Mr. Jennings has case number 240-595-1201 and case number 240-608-1201. He's charged in both cases with breaking and entering with intent. Let me see, I believe it's the same location. So two different locations. Judge Taylor, you set a $100 cash habeas bond for failure to appear at preliminary examination January 2nd for both cases. The floor is yours, Judge.
Starting with counsel for the people.
Good morning, Judge. It's always a pleasure to see you. Steve Vincent for the people, P719.
And good morning, Your Honor. Ryan Moran, P83665 on behalf of Mr. Jimmy Jennings.
All right. This is Mr. Jennings. Can you state your name for the record?
Jimmy Jennings.
All right. This is the date and time set for a warrant on this particular matter. Counsel for, I guess I'll let the defense talk first. Why didn't he come back?
I was waiting, the call.
So, Your Honor, in all honesty, he was arrested at the food bank. I think he's somebody who's struggling with a lot of poverty. I don't have a justifiable reason that's permissible to this honorable court as to why he didn't go to court. But what the reasons that I can provide you as to why he might be worth a second chance on release today to give him one more final opportunity. I understand there's been multiple KPS. I can't dispute that. It's horrible. I can tell you that, he's not working right now. The best thing that he has going for himself, he does have a stable residence with his father. I'm not sure, I know that there are some underlying issues. I can't necessarily articulate them right now, and I'm not in a position to, make assumptions. But what I can tell you, Judge, is, we have stressed with him the importance of court, and, his bond's $100. The saddest thing about this case is, this is just showing Your Honor about, the poverty that Mr. Jennings is going through. And I'm not sure if there's that underlying issue is getting in the way of him breaking out of that. But that's my assumption at this point, Your Honor. I don't have a valid reason for him missing court. I really don't. The best other thing I have going for him is when I run his name through the 36th District Court website, these are the only matters that are pending in this court that I'm aware of. So with all that going on, Judge, I can only ask this court for one more final chance. Again, I don't have the best reason, but I would hope the court would maybe find the compassion to give him one more opportunity to appear.
All right. Response from the people.
Judge, with all due respect, I think we're past empathy and compassion and consideration here. We have multiple capiases on one case. Actually, one ended up going to redetermination. And then Judge Williams ended up converting one of the failures to appear, the bonds, to a personal bond. And then the defendant, to show his proverbial, gratification or thanks for that, he ends up failing to appear at that next hearing date. And the only reason why the defendant, and I say this with empathy, I mean, okay, everybody's in different situations here. But the only reason why he was arraigned on a capias was because he got arrested on a new offense, the same type of offense that he was dealing with in the first case. And then he failed to appear again. So when we talk about chances, the defendant has been given second, third, and fourth chances. He's been given personal bonds. He's been given tethers. Nothing works. I mean, if personals don't work, if tethers don't work, I know we're talking about $100, but quite honestly, you had given him $1,000 capias before Judge Williams converted it to a personal bond. And now we're here today, and it's just a continuous cycle. So I can appreciate, I can empathize, but you know what? I have a job to do too, to make an argument as a direct result of this defendant failing to appear that he's a substantial flight risk. And that's what I'm trying to do here today, Judge.
All right. All right. The court has heard the arguments, and I believe that for my short time being on the criminal docket, he has capious me twice already. And so I haven't been able to get him in contact for this particular matter. I am concerned with him picking up new contact and then not reappearing. So I would hate for that to happen again. I understand the concern. It sounds like he does have whereabouts with his father, but his father is unable to get him to court, and it's not his responsibility to make sure that he finds his way back. We've called in officers on both occasions, and we have been unsuccessful, especially this last time. We had all the officers present for the preliminary exam, and he didn't come. So the court is going to keep bond as is. I do believe, even pending the fact that he has a place to go. We've tried everything. At this point in time, we just need to take care of these matters. I do believe that the $100 cash bond is appropriate in these matters. I'm going to keep it as is. I just need him to come to court and handle these matters. So I'm going to set the bond at that level. And this particular matter for those cases, both of them are to be set at $100 cash.
Okay.
Thank you, Your Honor.
Your Honor, the court dates will be bond redetermination will be Monday, January 27th, 9 a.m. in front of Chief Judge McConaughey on both matters. Probable cause February 4th in front of Judge Taylor, and preliminary examination February 11th in front of Judge Taylor on both matters.
All right. Thank you so very much.
Thank you, Honor. Good to see you, Judge.
Thank you. Good to see you too. Good
Okay.
luck. We'll see you soon, Mr. Jennings. We're gonna get this taken care of. Thank you.
Okay. All right. We are busy today. Okay, ma'am, what is your name?
India Lot.
Okay. This is case number 250-553-9701, Peterson, Michigan versus India Locke. Appearances, please.
Family, right? People, Your Honor.
And good afternoon, Your Honor. Good morning, Your Honor. Attorney Brent Jaffe on behalf of India Locke, who is present, retained counsel, and my P number is 81818.
Okay, the court are not good to plea on behalf. Wait for a reading, stand mute.
Yeah, I'm waiting for a reading, stand mute.
What she says.
Okay.
Yeah.
Okay. All right. Argument is the bond from the people.
Yeah, $150,000 bond and give the post bond. We're asking for Heather with home arrest. Very serious matter. The defendant, the complaining witness, were at a club or something. They came home. They were in an argument. The defendant said, "I'm going to shoot your ass." She goes to her vehicle, gets out a gun, points the gun at his head, and he's telling her, "Put the gun down." No, I'm going to, he said, "Stop pointing that gun at me." And when he's saying these things, listening to her, there's two neighbors, one of them who was watching the incident happen. She subsequently shoots him in the face.
Yes, I see that.
Okay, so, and as a result, we have a witness that saw it. We have a witness that was in the house that heard the shot, but heard her say that she was going to shoot him. Then she admitted on the telephone to someone else she was talking to that she shot the victim and get the bail money ready. Okay.
Okay.
So
what is that? What was the dollar amount? What's the dollar amount you're seeking, Mr. Ragnar?
$150,000 cash surety. She wasn't too concerned about having shot somebody. I think she explained it.
Right. All right. Counsel, your response?
Your Honor, thank you. So in connection with this case, Your Honor, my client was initially arrested. Well, when this initially happened, my client contacted me like the next day, roughly, or could be even that day. I made arrangements. I contacted the 9th precinct, I believe, and then ultimately Sergeant Anderson. My client voluntarily turned herself in, and then I made contact with the sergeant to, set up a time to meet between him and myself, and also my client. I went down to the detention center. My client was held there for 3 days, and then ultimately released because obviously, for whatever reason, they didn't have enough to put together at that point to charge her. And then now here we are. She's charged maybe 2 weeks later on these charges. Your Honor, I would say that I agree that that's the prosecution's, I guess, version of the facts. I would argue, and again, even though now is not the time to argue the case per se, but from our standpoint, this individual was charging my client with a history of domestic violence, and a single shot went off, Your Honor, in self-defense. That's what happened. Your Honor, my client has no criminal history. She has a tremendous amount of family support. She's gainfully employed. Your Honor, this is a very unfortunate situation, but it didn't just happen in a vacuum. And with the presumption of innocence, and then given the totality of what really happened, Your Honor, I think that this is a case that I feel extremely optimistic and confident about at trial. But that being said, Your Honor, we're asking for a further reduction, a more reasonable bond, either a 10% provision, or even a further reduction than that. I don't think my client poses any risk to the community, or nor is a flight risk. And for those reasons, Your Honor, I'm asking for, again, a reduction in the bond, or at least a 10% on the current bond.
Okay, the court having heard argument as to bond, and I thank you both counsels for a well-argued bond in this matter. Mr. Jaffe, I commend you for your argument as well. And particularly these domestic matters, what I find as a kind of like a tipping point of tipping the scales one way or another is where the incident occurred. Where do these allegations derive from? Do they come from the defendant's house or the complainant's house? And in this incident, based on the investigator's report, it is alleged that this incident occurred at the complaining witness's house. So logically, that dictates to me that the defendant came there with a firearm.
She has a CPL. She has a CPL holder, Your Honor. She has a CPL.
Regardless, Mr. Jaffe, she came there with a firearm. I'm not questioning whether she was, the legality of it. Regardless, she came there to his house with a firearm. Now, there could be a number of reasons for that. She may have come there for her own protection. I get that. By the same token, she may have come there to instigate something. I don't know that either. All that's conjecture. The point of it is that, but for her going to that location, the argument could be made that nothing would have happened.
They were together that night, Your Honor. I would just say that for whatever it's worth.
Mr. Jaffe, please don't interrupt me again.
My apologies.
Okay. And so whether they're together tonight, I don't care about that. She had a weapon, and carrying weapons and in many respects are inherently dangerous. Now, the reasons why the shot fired or whatever, that's going to be flushed out at a later court date when the facts are to be determined. But as of right now, I find that she is a danger, at least to the complaining witness. I am going to give her a cash bond of $100,000, cash surety. While this case is pending, she's not to possess any handguns, firearms, or other dangerous weapons. No contact with the complaining witness, and she cannot go to the Elmdale address where this incident allegedly occurred.
Your Honor, I appreciate that. As the court knows, I have the utmost respect for Your Honor, so my apologies for interrupting earlier, by the way.
No. I'm not offended. You were arguing zealously on behalf of your client. And one interruption I can get, two maybe, but you're I'm in the middle of my ruling.
Understood.
On that. So apology noted. No offense taken. Is this an unaffordable bond, Mr. Jaffe?
Yeah, it is, Your Honor.
Okay. Bond redetermination will be Monday, 9 a.m. in front of Chief Judge McConico. Public call January 31st in front of Judge Giles. Preliminary examination February 7th in front of Judge Giles. Now, Mr. Jaffe, is there anything else you want to put on the record?
No, Your Honor. Thank you very much for your time.
Okay, thank you.
Thank you, Your Honor.
You step out. You step out. Come on, man.
All right, we got Ms. Pigler.
Yeah, absolutely. Tell me the name, say your name on the screen.
Patricia Pigler. Okay, I'm here, Council Ford.
Behalf of Miss Pigler. And her husband
Okay.
is, he made it back in my office. He's to my right. He retained as a representative.
Okay, Council Ford, start over. I caught you in mid-sentence. Your appearance, please.
Oh, Debbie Bledsoe Ford on behalf of Miss Pigler. And I was retained by her husband about an hour ago. He's here to my right.
Okay, you waiting for a reading stand mute?
Yes, Your Honor.
All right, the court read a not guilty plea on behalf of Ms. Pigler. Here's Mrs. Coyle.
Good afternoon, good morning, fellas. Lisa Coyle appearing on behalf of the people.
What's your bond recommendation, Mrs. Coyle?
Your Honor, the people in this matter, I do not see a criminal history, thus no capious history for Ms. Pigler, although it is assaultive over the belief that the complainant was stealing gas. They don't know each other. They are strangers, which does make a difference. This was at a public place at a gas station. And I do note that in the gas station, in the IR, it does not say anything about on the video being a gun. So for those reasons, Your Honor, and I do note that Ms. Pigler is the CPL holder. So the people are recommending a bond of $50,000 personal, no weapons. That includes, even though she has the right to carry a CPL, at this point, I'm asking the court to suspend that right and no contact with the complainant, Ms. Simpson, who is a 69-year-old woman. She's older. She allegedly was attacked with the weapon, although that is a point of contention. But at least we know she was attacked with a gas pump, which is metal. And the police officers did observe a lump on her head. So for those reasons, Your Honor, that is for my bond recommendation.
Council Ford, response?
Yes, under my understanding that the complainant was the aggressor, and it was over gas, or the gas pump, rights to the gas pump. Who paid first to that gas pump? But it was correctly stated, my client has no prior history of any kind, criminal. And she's been married 15 years. And
Do you have an objection to the personal bond?
Yes, I was gonna ask for 10,000 personal.
Okay. All right.
Because of the fact okay, go on.
Go ahead.
I'm sorry.
No, go ahead.
Well, I believe there's gonna be a winnable issue about who had rights to the pump. And the fact she is a CPL holder, had a gun, but she did not pull it out. And there was no intention to do great bodily harm or to hurt the complainant in any way, just to defend her own self and turf. And for those reasons, I think it's an overcharge, and I think many of these charges will get dismissed.
Okay. Court ever heard arguments the bond. Council Ford, you may very well be true. But at the next, as you well know, at the next fact-finding stage, the preliminary examination, all these facts will be flushed out. And you may very well be right. It may be dismissed at preliminary exam. But once the facts come out, that may very well be true. But as of now, I'm going to adopt the recommendation of the people, $50,000 personal bond. While this case is pending, you're not to possess any handguns, firearms, other dangerous weapons. No contact with Diane Simpson. You cannot go back to the Winston address while this case is pending. Probable cause, January 31st, preliminary examination, February 7th, both in front of Judge Giles. Council Ford, is there anything else you want to put on the record?
No, but it's great to be back.
Good to see you, Judge Ford.
And you too.
All right.
It's great. It's
right.
great. Thank you.
All right.
Bye.
Bye-bye.
Bye-bye.
Bye.
Okay, Jose Vicente. Ms. Cox.
Yes, Your Honor.
Say the best for last. Prime time, Ms. Cox. Prime time.
All right.
All right, Ms. Cox, raise your right hand. You swear or affirm that you will translate from Spanish to English, English to Spanish to the best of your ability?
I do.
All right, put your hand down. All right, these, I gotta speak slowly for Mrs. Cox. All right, this is case number 250-554-3601. And case number 25, oh, go ahead.
Ese es el caso contra el señor José Vicente 25055433601.
And case number 250-554-3201. Both matters, People State, Michigan versus Jose Vicente.
Y el otro cargo es 25055433201. Los dos, el Estado contra José Vicente.
Appearances, please.
Samuel A.
Diga su nombre
Ragnan for the
para las
people.
actas.
Oh,
El
Mr.
abogado Ragnan representando al Estado.
Brad Murad, P83665 on behalf of Mr. Vicente.
Y el señor Murad representando al señor Vicente dio el número de su licencia.
We
Right.
waive the
Mr.
reading and
Cox.
stand mute.
Okay.
Nosotros renunciamos a que lean los cargos y se queda en silencio.
All right, the court will enter not guilty plea on behalf of Mr. Vicente on both matters.
La Corte va a aceptar una declaración de no culpable a favor del señor Vicente en los dos casos.
Argument from the people is the bond.
¿Qué dice el Estado con respecto a una fianza?
Your Honor, with regard to the incident on 1/19/25, okay, the defendant and the complainant.
Please don't go over the facts. Just give me a bond recommendation and the gist of the facts.
Just of the
Okay.
facts is the defendant pulled a knife at her, pointed a knife at her, and threatened her. Okay? And I'm
Right.
asking, in addition, he tried to block the knife. They got into a tussle, I guess, and her wrist was cut, Your Honor.
Lo que pasó, le pidió el abogado al abogado fiscal que explicara lo que pasó rápidamente. Él dijo que usted sacó un cuchillo, un puñal, ella también, y empezaron a forcejear, y mientras pasó eso, ella le cortaron en el brazo, en la muñeca.
Asking for 25,000 cash surety on that case and tether house arrest if he's able to post bond. With
Y
regard,
lo que,
sorry, so sorry.
la fianza la están pidiendo que sea de $25,000, que tenga que pagar el 10% y que esté bajo orden de arresto y no puede salir de su propia casa.
With regard to the incident on January 22nd at 12:07 a.m., defendant kicked the door in, busted into the bedroom where the complaining witness was sleeping with complainant 3. He starts beating him up. She yells for help. 15-year-old son comes in, complainant number 2, tries to calm him down. Defendant's friend comes in, brings him outside. He then goes back.
Pause. Hold on. Let the interpreter talk.
Entonces, lo que
Okay,
pasó 2 días después es que el acusado forzó la entrada por la puerta, fue al cuarto donde estaba una de las acusadores durmiendo y el otro acusador número 2 empezaron a pelear, empezó a pegarle. El hijo de 15 años, que es el acusador número 3, trató de calmarlo, pero lo sacaron para afuera, se fueron para afuera y continuaron peleando.
Defendant
Go
came
ahead,
back.
Mr. Ragnar.
Defendant came back in the house the second time, wanted to take his son and a credit card from the house.
Y el acusado volvió a entrar a la casa y se quiso llevar a su hijo y una tarjeta de crédito, sacarla de la casa.
The son was 1 year old. The complaining witness 1 said he was drunk.
Ese niño tiene 1 año de edad, pero la tercera persona que lo acusa dijo que el acusado estaba borracho.
So what is the dollar amount you're seeking for both cases?
$35,000 cash surety on this case, 25,000 cash surety on the felonious assault case, tether house arrest.
Entonces,
Okay, and I know for the record, I'm sorry, go ahead, Ms. Cox.
¿Cuál es la fianza que están pidiendo? Por el segundo caso, $35,000 de los que tendría que pagar el 10%, y por el primer caso de una agresión mayor, $25,000 y que quede bajo arresto en su propia casa sin salir.
Okay, thank you, Mr. Ragnar. And this is for a question for both councils, if you know, how many children in common do they have?
Esto es una pregunta para los dos abogados. ¿Cuántos hijos en común tienen ellos?
They have two. One is 1 year old, and the second one is 6 months old.
Ellos tienen dos. Uno tiene 1 año y el otro tiene 6 meses.
Go ahead, Mr. Murad.
Ms. Murad, señor Murad, ¿qué dice?
Your Honor, I'm going to highlight main points only.
Voy a decirle nada más las cosas más importantes.
My client has no criminal history whatsoever.
Mi cliente no tiene ninguna historia criminal.
Is a hardworking family man who supported his family of 3.
Él es un hombre muy trabajador que mantiene a su familia de 3.
He most definitely understands to have no contact.
Él entiende completamente qué significa no tener ningún contacto con ellos.
There's no presence of threat in either case.
No hay ninguna amenaza en ninguno de los dos casos sucedió eso.
With the first case, any injury is alleged to be over a struggle, not necessarily an attack of the knife.
El primer caso, esa lesión que se cortó fue porque estaban forcejeando, no fue porque él la atacó.
That injury is described as minor.
Y eso fue una cosa menor, una lesión menor, mínima.
No one went to the hospital.
Nadie tuvo que ir al hospital.
I'm asking for personal with GPS house arrest on both cases. I think that's a fair bond given the circumstances.
Yo estoy pidiendo que le den una fianza personal, que creo que sería justo, y que le pusieran un grillete con GPS, y eso lo mismo para los dos casos.
You said he was working, is that correct?
Usted dice que trabaja, ¿eso es correcto?
He does construction, Your Honor.
Él trabaja en construcción, Sonoría.
His hours do vary.
Y sus horas varían.
Trust me, I know. My father was a construction worker. I
Eso
know.
yo lo sé. Mi papá trabajaba en construcción.
Papá está en Guatemala, está
Sir, I
muerto.
do not want you to speak.
Señor, él no quiere, su abogado dice, por favor, no diga nada.
Okay. Mr. Murad, you bring up some good points, as you always do.
Señor
But
Morales,
what is
usted dice cosas pertinentes, como siempre lo hace.
what I find particularly troubling in this situation
Lo que me preocupa más en este caso
is that you got 2 cases here, 2 incidents within a very, very short time period.
es que hay 2 casos que pasaron en muy corto tiempo.
With the same complaining witness and the same address.
Con la misma persona que lo acusa en la misma casa.
And an argument could be made just based on these allegations that he's kind of stalking her.
Y se podría decir, basado en estas acusaciones, que él la está persiguiendo.
And with the allegation of a knife being used, particularly in one of the cases,
y como dicen que en uno de los casos estuvo presente un cuchillo o una navaja,
I find that he's a danger to her.
Yo creo que él es un peligro para ella.
And I'm going to partially adopt the recommendation of the people.
Y voy a adoptar parcialmente lo que recomienda el Estado.
It's going to be $25,000 cash surety bond on both cases.
$25,000 de que tienen que pagar el 10% por cada caso.
No alcohol on both cases.
No puede beber alcohol. Es una restricción con respecto a los dos casos.
No contact with Ms. Huerto, Jesus
No puede-
Martinez, and Ricardo Velasquez.
No puede tener contacto con la señora Huerta, el señor Ricardo Vázquez.
Can I go back to the Gruzel address where this incident allegedly occurred?
No puede regresar a donde esto sucedió en la calle Grusel.
And on the case ending in 543201, if he's able to post bond, fitted with a GPS tether, 9 p.m. to 6 a.m. curfew.
Entonces, en el caso que termina en 4320, tiene una orden de queda que no puede salir de la casa y le pondrían, si puede pagar para salir, le pondrían un grillete.
I am not going to impose a tether on the other case.
Pero en el otro caso no voy a mandar que tenga un grillete.
I assume this is an unaffordable bond.
Yo creo que esto es algo que él no puede pagar, ¿correcto?
Unless you'd consider a 10% provision because of his lack of priors.
A menos que usted considere que nada más tiene que pagar el 10% porque él no tiene ninguna historia criminal anterior.
No, counsel.
It's unaffordable.
Request denied.
Entonces,
Okay.
entonces mi cliente no puede pagar eso.
All right, so bond redetermination on both of them will be Monday, January 27th, 9 a.m. in front of Chief Judge Mechanical.
La primera audiencia para que un juez decida si le rebaja la fianza será el lunes 27, el próximo lunes a las 9 de la mañana con el juez de apellido Mechanical.
Your Honor.
Probable cause. Let me finish, Mr. Ragnar. Probable cause, January 31st. Preliminary examination, February 6th, both in front of Judge Jack Kay. Ms. Cox, go ahead.
I'm sorry, Your Honor. Would you say those two dates? I did not write them down. I'm sorry.
Okay. No, I probable cause be January 31st. Preliminary. Go ahead.
La próxima audiencia después de eso será el 31 de enero. Eso se llama causas propias.
Preliminary examination, February 6th, in front of Judge Jack Kay.
Y lo que se llama examen preliminar, el 6 de febrero, frente al juez de apellido Jack Kay.
Yes, Mr. Ragnar.
Señor Ragnar.
I just wanted to know which case you were not putting a tether on, that's all.
¿En qué caso
Case,
le va a poner el grillete?
Case ending in 5436.
Thank
que
you,
termina
Your
en 5436. Gracias, Honoría.
Okay. Have a good day, everybody. See everybody at 2:30.
Thank you, Your Honor. Thank you, Ms. Cox.
Thank you.
Ms. Murad.
Have a great
Thank
day.
you. Nice
Buena
to see
suerte,
you.
señor Vicente. Ya terminamos. Se puede ir.
I gotta say this. Oh, he's gone. Never mind. I'll say it